So welcome. I am Michelle McCabe with the Horizon Results Platform, which is part of the results valorization efforts at the European Commission. We are delighted to partner with the European IP Helpdesk experts again this year to offer a series of dedicated IP-related webinars for you. Today, the webinar will be focused on publishing versus patenting. And before handing over the floor to Michele, let's look quickly at what the Horizon Result platform offers. Next slide. So the Horizon Results platform, or HRP, showcases about 3,500 innovative EU-funded research results coming from EU-funded programs. So Horizon Europe, Horizon 2020, FP7, the European Institute of Innovation and Technology, or the EIT, the Research Fund for Coal and Steel, and the European Maritime Fisheries and Aquacultural Fund. So we work with partners such as the EIT, the EIC, the EEN, the European IP Helpdesk, obviously, EBAN, which is Business Angels, and BAE, the second Business Angel network in Europe, and the Solar Impulse, and more, to organize lots of activities and events for beneficiaries. Next slide, please. And so we have, today we're showcasing mainly the supply side, working with partners to help innovators and founders advance on their go-to-market and scaling up journey. And we are also preparing tomorrow's platform, which is the launch of a larger innovation platform incorporating not only the supply side of innovations, but also the demand side actors. So investors, corporates, business support services, a lot of experts in there, and the municipalities, the non-for-profit, the research and technology offices, all of those that make up the demand side, that will be able to create their profile, just like for the solutions, and present what they offer and express their needs and target audience and have some matching happening in an automated manner. So, we do have the commission services, the go-to-market business support via the booster, the EU IP Helpdesk, the EEN, the EIT, and more. And we organize a lot of thematic events and networking. So, for example, in late September, there'll be an e-pitch with one of the EIT kicks, which is urban mobility. And there'll be others as well. And we have dedicated go-to-market webinars. For example, Tuesday, we had Funding Done Right for Startups, Part 2, which was given by BAE. And there are others that will come. And we also have the corporate innovation challenges, such as those organized by Axio, which is part of the EEN Spain. And we have the partner search on the platform where you can go and actually look for partners. We just finished the successful Empowering Startups and SMEs pilot, where innovators or founders who pitched or held an exhibit stand or brokered matchmaking meeting for an open innovation challenge had their event-related expenses reimbursed by the Commission. And we had lots of very interesting events such as Slush or the EBAN Congress or the EBAN Summit, space-related, food-related, etc. events that innovators and founders were able to take advantage of. So in general, we have over 50 startups on HRP that have attended thematic matchmaking and brokerage events. Over 90 have pitched, and we have thousands that have had the free of charge go-to-market support services. We have thousands that have attended dedicated training webinars to enhance their journey, such as today, and there will be more. And we have lots of interesting success stories coming from that. Next slide, please. So we also have HRP TV, and there are two channels. One is the Experts Say. So, for example, that's where you'll find the Funding Done Right for Startups if you're interested, business modeling and planning, working with business angels, entrepreneurship for research, etc. Or the channel Get Inspired, which is looking at and celebrating the successful founder innovator journeys from lab to market. And they share their learnings on their way as well. Next slide, please. All right, and here you will see that there are two more in the series coming up this year. October will see the technology transfer, and November the unitary patent topics coming up. And we hope you'll be able to join. And then you have links here for the platform. If you haven't been on it, please go. If you're EU funded, please publish your exploitable results there. And you can access HRP-TV from there as well. And then it's how to publish on HRP. And if you have any questions, I think I have the email on the next slide, Michele. So you want, yes, there you are. So please don't hesitate to reach out. And now I'm going to turn the floor over to you, Michele. Thank you. Thank you so much for organizing.
Thank you. Thank you very much to you, Michelle. It's always a pleasure to team up with the Horizon Results platform on the European IP Helpdesk's side. I am always happy, of course, to have the chance to collaborate. I'm going to show myself for this beginning of the webinar, and then I will come back in my visual, let's say, for the question and answer part. This is in order to, let's say, allow you to have a better view of the slides, and also because there are some potential problems in the last few days with the internet connections, especially of the participants. So having also a camera throughout the whole duration could be a little too much for some connections. So I wanted to show myself and greet you, and also introduce myself why I'm showing the video. My name is Michele Dubini, and many of you might know me from the European IP Helpdesk because I'm pretty much present at the trainings. I run the training part of the European IP Helpdesk, and I have a couple of contents that I personally carry out, like, for example, IP new funded projects, or also introduction to intellectual property and intellectual property rights. Today, I have challenged myself with a very, very interesting and important topic, which is the concept of publishing and patenting, because this is the first time that we are doing this webinar. I would kindly ask you, after the webinar is over, to fill in the feedback forms so that especially I can know what you think about this webinar. It's especially important for me because I have created this content, and so to know how you would think that it could be improved is very, very interesting for me, of course. And please just be brutally honest when you will have to fill in the feedback form if you will want. Having said that, I'm going to turn off my camera. Just for the others who do not know me, I am a lawyer. I'm specialized in intellectual property law, and I basically devoted my career to the usage of results proceeding from Horizon funded projects, Horizon Europe now, Horizon 2020 before, and even a little bit of FP7 in the prehistoric times where I started with my career about 11 years ago, almost 12. Before we start with the technical content, as we usually do, I'd like to provide you with a couple of administrative information regarding, first of all, the tool that we are using, which is GoToWebinar. You might have noticed that your audio has been muted and will be muted throughout the whole duration. This does not mean, however, that you're not allowed to ask questions. You're very welcome to do so. And if you check, you see that you have a small box with a question marks in there. So you can type your question into that question boxes, and after that, at the end of the presentation, I will gather all the questions, and I'll do my best, of course, to provide you with an answer. The question that we always receive, most frequently asked, is when are you going to be receiving the slides and the recording of today's webinar? That is going to happen at the latest tomorrow morning. Hopefully, I'll be able to already send you everything this afternoon. I just need to cut and the slides and the presentation and send it to you. But it's going to be a follow-up email with a link that will allow you to watch the webinar again if you want, or distribute it also, and PDF slides attached to it. So much, let's say, for the housekeeping part. Now allow me to say a couple of words on the European IP Helpdesk, which is the initiative for which I'm working for, and that allows us today to be together. This is a service initiative of the European Commission that has the main objective of helping small and medium enterprises, researchers, and beneficiaries of youth-funded projects, mainly understanding and using intellectual property and intellectual property rights. Those three categories are the ones that statistically require the service, which you can see on the right-hand side of the screen the most. However, they're not the only ones, and theoretically the services are open to all physical and juridical persons who might have questions regarding intellectual property and IP rights. Everything we do is free of charge, but it's also, please remember, a first line support, which means that we're there to provide you with the most needed first aid information in order potentially to prevent you doing some rookie mistakes. For example, that, as we will see today, early publications in comparison to patent protection. Other than that, we offer trainings. We are at the end of our first semester. This is actually our last training, and we will be back in September. But through the website, you can have access to all the past trainings in our e-learning page. And also you'll have access to publications, which we will see later on. Additionally, there's the ambassador scheme, ambassadors that are scattered all across the European Union and in some cases even beyond, like Turkey, the United Kingdom. And finally, probably most importantly, there's the helpline service, which means that you can ask specific questions to our helpline team and they will answer you within 3 working days. The territorial coverage of the European IP Helpdesk is, of course, the European Union, but with a couple of additions, in some cases exotic as well, have become in the last year at least. Because if the United Kingdom has left the European Union, but still is an Horizon-related country, and so it's part of the family of the European IP Helpdesk, so it is Norway and Switzerland, but also Canada, example, and even from last year, South Korea. This is the territorial coverage of the European IP Helpdesk, but if you need specific information regarding intellectual property in other areas, you can see our siblings in China, India, Southeast Asia, Africa, and also Latin America. They provide the very same services that I've introduced for the European IP Helpdesk, but with a different geographical scope. Also, we offer publications online. You can see them in here, e-learning modules, guides, fact sheets, and that are topic, country, or sector specifics. There are infographics and also interesting case studies developed together with the European agencies and also the European Patent Office. Our contacts here again, in case, for example, you'd like to retrieve one of our past webinars, we're going to be happy to provide you also the information in case you cannot find them on our kind of complicated website, to be honest. But also, if you don't find the helpline section, you can type directly an email to this account here, helpline@iprhelpdesk.eu. Then there's X and LinkedIn, where we are active. And also, if you want us to communicate information directly to you, there is our newsletter. You can subscribe, and then we will be the one getting in touch with you. So finally, there are a few minutes already. We're all set to start with our technical content of today's webinar, which again is publishing versus patenting as the title. What I tried to do in this webinar was to provide an overview of those 2 activities, let's call it like that, that can find their place in, let's say, our day-to-day activities, in a company day-to-day activities, but especially within the framework of Horizon Europe funded project, of EU funded projects. Because those are, I would say, necessary steps that have to be done in order to reach the impact that the project needs to yield to the European society, economics, and in a contractual way to the European Commission, who is basically the contractor of the project itself. And so we will analyze the status of the publishing activities, of the patenting activities, and we will see a couple of techniques that are in a way interesting when it comes to understand the tactics of publications and patent protection. An example of this is defensive publication. How to understand them, first of all, and also to use them at your advantage potentially. And we will clear out what is the concept of patent, what it does, what is a patent, and how it fits within the protection landscape, of course, but also in the dissemination landscape. Then we will tackle the concept of open access, which is definitely connected to publication, but you might be pleasantly surprised to see how that is connected to patents as well. And the fact that having information open and online doesn't mean that they are automatically free to use or of common knowledge. So our main message finally will be, and I anticipate this to you, to balance the protection and the dissemination activities. And then I'll try to go through a couple of real examples, one of them on the defensive publication, to be sure that you can best understand this topic. I will also have one final slides with useful tools that can be used and that I have used actually to create these slides. Again, I'm very, very eager to know what you think about them. So after the webinar, there's going to be a feedback form to you. So let's start from the say legal framework of Horizon and trying to analyze why publishing or protecting, why being prepared to those two activities actually is very important for all beneficiaries of EU-funded projects. But first of all, because they are channels for dissemination. And dissemination, when we say the word dissemination, we are actually meaning scientific publications, we're meaning conferences, workshops, seminars, but also what is published on online platforms like Cordis and Odos and so on. But dissemination, let's say databases as well, are the patent research engines, like, for example, SpaceNet and also Google Patents. This is something I will reiterate throughout the whole presentation. The fact that when a patent is going to be published, even a patent application is going to be published after 18 months, it will be published in those databases, which are free of access, which allow the reuse of the information and somehow comply with the all fair principles, findable, accessible, interoperable, and reusable principle that are a necessary requirement of dissemination activity. But on the other hand, the dissemination is there in order to empower the exploitation, which means to allow potentially interested third parties to use the results that have been disseminated, and so to facilitate the future exploitation or to start a partnership in terms of the usage of results and also funding. And under this point of view, of course, both of those dissemination activities, which can be considered patents and publication as well, are important, but they work in a slightly different way. taking into consideration the patent protection and the monopoly that a patent builds up around the protected invention or the generated information. And we will see this coming up in the upcoming slides. When we analyze the grant agreement of every project, we will see that under an intellectual property point of view, a hugely important point is the general obligation to protect. Basically, the Commission tells us that each beneficiary must adequately protect its results for an appropriate period and with the appropriate territorial coverage whenever protection is possible and whenever protection is justified. Now, in our webinar IP in EU-funded project, we analyzed those two concepts of possible and justified. But just for you to bear in mind quickly in this webinar, not all intellectual property generated by the project, so not all results are protectable by intellectual property rights. So protection might not be always possible. For example, a simple idea may not be protected in any form or way. And regarding justification, well, you need to take into consideration what is it that you want to do with the project results before starting the protection activities. Say, for example, that in your description of action, you have written down that you are going to be creating a software that can be used by everyone, the community can build upon, and it's completely free and open to be modified by the user. So probably in that particular case, protection even patent protection is not going to be particularly justified. Just a couple of examples to allow to understand the basics of the general obligation to protect. And patents and publications are, for the general obligation to protect, two very important tools to be applied because the patent is, let's say, I would say, queen or king or prince of the protection method because it is the perfect method to ensure that results are not going to be misused by third parties without our knowledge, without our allowance also in a way, because they secure exclusive rights that allow the owner to decide who might license the invention protected, who might commercialize it, who might import it, who might export it, and very importantly, at which conditions. So for let's say what kind of counter payment should be done in order to have this right to commercialize, to import, to export, and for which territory and for how long, so for which amount of time. And you can imagine that this is a considerable advantage when it comes to the preparation of the exploitation results because as you know, exploiting a monopoly for the monopoly holder is much easier than operating, let's say, in a free market where everyone has the same rights. But in this particular case, the monopoly holder has earned his rights of deciding who and how results, the invention may be used because he put in all the valuable work that led to the creation of the invention itself. And so with patents, we have the king of the protection method. Let's say, downside of this is that not always patent protection is applicable. Patent protection is applicable only to inventions, and inventions are, let's say, a tiny part of the output of the project results that are generated. Inventions are also, patents are applicable to inventions that are new and that are inventive and we will see later on also this point in here. So let's say there are a few restrictions that identify as patentable only a fraction of the results that are generated. Instead, with the publication, we cover a much larger spectrum of potential results that might be presented through this kind of dissemination action. However, the protection provided by the publication itself is much lighter, in the sense that the publication or the copyright protection that applies to the published paper does not grant, let's say, the exclusive right, or it does not do it with the strength of a patent. In fact, it does not directly protect against a third-party use, which means that nobody can certainly take our publication, copy it, republish it, or translate it, or adapt it without our permission. However, if something is described inside the publication, for example, the invention that we, in our other life, let's say in our other example, had published through a patent, we wouldn't be able to stop the use of that invention as we would be with the claim of a patent, with a patent and its claims. So both of them, in a way, both publishing and patenting are a way to fulfill the general obligation to protect, but in two different ways and for two different purposes. And additionally, we will see this later on in the upcoming slide, we need to pay a lot of attention when publishing, because the publication as a dissemination method is basically activity that has to be done once we have ensured 100% that all protection methods are not applicable. Because in many cases, like for the patent, if we publish before protecting, before patenting, then the patent protection is not going to be a viable protection method anymore, because it will be not novel, because the information on the invention, at least completely or at least part of it, has already been disclosed and is part of the state of the art. And so we said basically that patents and publications are a way to fulfill the general obligation to protect in their two different exceptions. Well, they even fit better when it comes to the dissemination, the obligation to disseminate. Why? Of course, publishing here is certainly the king or the queen of dissemination activities, because we publish in specific journals that probably are going to be read by specific target users that are going to be able to read and learn, and so also doing further activities that then, let's say, fulfill also exploitation methods. And so the scientific journals in which we will publish, they will be, let's say, the bridge to allow the information to be sent also outside the project and to third parties and so on and so forth. So no doubt that publication is definitely a very good way to disseminate the project results. And however, very often it is forgotten that also patents are a very efficient way to disseminate project results. Because if you check for a patent document, and by chance, I think I have one in here on SpaceNet, you will see that all the information regarding the invention that is protected is actually available. Not only that, there's drawings, there are claims, there's the original document of when the patent had been file. So everything we want to know regarding the technology that has been protected is actually online. It's findable, it's accessible, it's interoperable, and it's even potentially reusable if it's not under a commercial environment. It's reusable, of course, if we have the allowance of the holder of the intellectual property rights of the holder of the patent. So never forget, and we will get back also to this topic later on in the upcoming slides, that patents are a very, very powerful dissemination method of technical information, and just like publishing. So if, for example, you have a very interesting project that you want to write a proposal for, and you're thinking about potential patent protection activities, maybe from today you can also think about saying to the evaluators that you will be disseminating also through the protection method of the patent, because again, after 18 months, the patent application is going to be published and the patent documents are going to be anyway available online to anyone who might be interested, who wants to learn regarding the technology and the information, who wants to build upon it. But in the moment those people that have access to the knowledge want to use the results in a commercial pattern, wants to then exploit those results in other environments, they then will need to have the allowance of the holder of the patent, unless of course the patent has expired. And to do that, they are going to be needing a license. And so when we talk about the purpose of patent and publication, so let's say we can how we can use them is quite clear. We can both use them to fulfill our obligation to protect and to fulfill the obligation to disseminate very effectively. But regarding their purpose, they have a slight different, I would say, from one another. In fact, the main purpose of publications is on the scientific progress and the societal benefit, and in order to share and the findings and open, and so that all the community can build on the previous work, receive peer recognition, and so on and so forth. So this goal is actually covered by the patent protection as well. But we add a layer to this, which is the transformation of that research activities into basically into commercial output, which normally is a very effective form of exploitation. And so the fact that we are sharing information through a patent is a first step. But then we add this additional layer that fulfills the exploitation imperative that says, all right, you can learn from it, you can have access to that information that's free for you to know, but if you want to use it under a potentially commercial point of view, then we will need to, let's say, discuss it in the form of a license, because I am the one, as the inventor, who put effort in the creation of those results, who spent hours and hours trying to understand how this invention would work and made it work finally, and then protected that in this in this legal framework, which is the patent protection. And so if we then make a step back and analyze the characteristics of the scientific publications, we see that the main objective is to disseminate the findings to the scientific community, and scientific publications are definitely vetted. they're peer-reviewed, they are required by the academics for career progression, and that's a crucial point of the relationship between patent protection and scientific publication, therefore between companies and academics within Horizon projects, Horizon Europe and Horizon 2020. They provide a disclosure certain in time. So there's going to be a date for the publication, and this date has a very large importance when it comes to protection, because that date is going to be taken into consideration by an examiner, for example, while addressing the information that should be taken into consideration to understand whether a invention is novel or not. And for a career, as I was saying, is of utmost importance, because for researchers, for a scholar, reputation and networking completely depend on their scientific publication, on what they publish. But this is the hurdle, actually, of the relationship in an Horizon project between the scientific publication and the patent protection, because academics will do their best in order to publish as much as possible, as early as possible, whilst company will tend to be more reflexive and see what could potentially be protected, what could provide them with this monopoly edge that would make it much easier to commercially exploit the result potentially later on. And the sword, let's say, stays in the middle, in the sense that uh, doing publication too early and too quickly and without communicating that properly to the other parties may make impossible for the partners of the consortium to protect and patent, and so reap the economical and exploitation advantage of a patent that I was talking about before, because the information, once published, is not going to be novel anymore. The characteristic of the patents as well here, again, I'm going to stress it throughout the whole webinar, we are sharing information through a patent. Everything that we protect through a patent is going to be freely available for the scientific community to know, to understand and learn, just like a publication basically is. You can read a patent the same, even easier actually, than you can read some publications that, for example, are not open access. But when the moment comes to use those results potentially commercially, then the discipline is different, as I was describing before. Additionally, in order to be able to patent our inventions, the invention has to be novel, which is a huge point of discussion within Horizon Europe. It has to be inventive, and it has to be also industrially applicable. We analyze in detail all these points in our webinar, Introduction to IP. So I would then redirect you there in case you want to know more in detail about that. I will say a couple of words, but not as detailed as in our other webinar. And they are also vetted as publications are. It's not really a peer reviewed, because it's not peers that are analyzing our patent. I would say examiner are in a way a step above us, because they're the judges basically who decide whether there is novelty, whether there is inventive step, and whether there is industrial applicability. But they're vetted because this examination is very thorough, is done by in Europe by the European Patent Office, and some national patent office do it as well. There's also the USPTO in the United States that analyzes these patentability topics that I have just mentioned. So a very thorough examination process that is applied to the invention that wants to receive this patented status that basically allows the users to take advantage of the monopoly I was talking about. Also, if a publication is available worldwide, also a patent is actually available worldwide. Everyone can see what is written down in the SpaceNet repository of patent in the research engines. However, the monopoly, the protection granted, only works for a certain territory that is chosen by the inventor, by the patent holder, in the moment in which he or she wants to receive the granted patent and the patent protection. It can be, for example, the United States through the USPTO. It can be the European Union with the unitary patent now, or even different countries within the EU. It can be China, and so on and so forth. Again, so if I would have to tell you what is the main difference between publishing and patenting, I wouldn't certainly start from the dissemination part, because I think they are very effective ways to disseminate, both of them. However, when we're talking about patents, we have this additional layer of protection that allows the users to be more effective in a way when it comes to commercializing the project results. Again, however, they're applicable only to a fraction of results that are generated by the project. And if you statistically check all the project results that are created in Horizon Europe, you will find that probably only 15-20% of them are mature enough to come up with patents as IPR method for protection of their results. Uh, there's a major problem, and I've been now, let's say, flying around it like a bee and a flower in the last few slides. We see that in, for example, in consortia that have a composition that brings together academics and companies, especially when we're talking about big conglomerates of companies, which are the potential, and this is the potential risk of early disclosure. The early disclosure happens when a publication is issued, is published very early, probably too early, compared to the time in which it should have been published. So here we are in the situation that where, let's say, the balance within the consortium is completely disbalanced towards the interests of the academia. And definitely there is advantages of early disclosure, but they are tangible only on the academia side, in the sense that you are advancing science and visibility, you are complying with the dissemination obligation. However, you might be endangering protection, so you need to be careful about that. But you are, let's say, also enhancing the CV. You're doing the activities that are necessary for a researcher in order to progress basically in his career. But this disbalance, of course, creates problem for the consortium in general. First of all, publishing too early could make impossible for the consortium to receive protection, patent protection later on, because what has been published is already part of the state of the art, and what is part of the state of the art is not novel, and what is not novel cannot be protected, which means novelty is destroyed. Additionally, there are rules in not just the grant agreement, but also in the consortium agreement. There's a dissemination checklist that says that normally you should communicate 45 days in advance to the other parties that you are going to publish certain results, so that these have the time to decide whether actually they should be start the protection activities before the publication is issued. In that way, they would safeguard novelty. And so, yes, sometimes, unfortunately, it happens, and the European IP Help Desk is there as well to counsel, let's say, for these potential problems by saying what are the risks of publishing at a certain time, and especially whether there are specific rules from your consortium agreement, for example, that should be taken into consideration before publishing. In many European projects, unfortunately, early disclosures are a problem. They are a problem that also mirrors on the exploitation activities later on. Because think about, for example, very interesting results that are going to be published in your in your paper, of course, project results of a project that was going to create, say, a compound that would potentially, with a pill, improve the situation of a patient with prostatic cancer, if not, let's say, cure the prostatic cancer. A patent is definitely a very powerful way of exploiting these results, because you can go to pharmaceutical companies and say, look, I have this very interesting invention that is patented. Would you be interested in the production of this compound? And then they would say yes or no, but still they wouldn't be able to simply take it and produce it themselves. If you publish the chemical status of the compound beforehand, and you even in the most important journal in the world, this exploitation method of going to the companies and try to license out the compound to be produced is suddenly not going to be viable anymore, because you don't have the monopoly, the patent leverage that could have prevented others from using the compound that has been then published. And everyone can see that publication, and that is the core difference. Everyone can see the publication and can use it, because copyright does not protect the content of the compound in itself. Whilst with a patent, everyone can see the content and the compound as well, but nobody can actually use it without the consent of the party, the creator. And so the solution is actually a balance strategy. We need to think, the consortium needs to think before the publication. Is there anything patentable in there? Are there other methods of protection before publishing? Yes, no, and then act. Have all partners agreed? Did we talk about that? Yes, no, and then act. Did we have provisional filings? This is a very important point, and I want to stress a little bit regarding that. So the patent law basically works like this. An examiner is going to be receiving the patent application, and he or she is going to check whether the invention is already part of the state of the art. If the invention is part of the state of the art, then they're going to tell us, I'm sorry, but unfortunately, I am not able to grant you a patent because this invention has already been described in detail on the 3rd of March 2025 in the publication that was issued on Nature Journal and so on. However, the examiner has, let's say, a boundary, has boundaries in which he can search for information, and he may not search after the application date. So let's say that the publication was on the 3rd of March that we have issued, but our application was on the 2nd of February 2025. Well, then in that particular case, the examiner will not be able to take into consideration a publication that has happened after the application filing, the filing of the application of our patent. And that is very important, because this allows us to bypass this risk of early dissemination. Also, the state of the art will wipe novelty only if it's specifically described, which means that, for example, regarding my example that I was doing before of the prostatic cancer, if I write into a poster of a fair that I am about to produce a cure to prostatic cancer, of course, that's not going to be a novelty breaker because it's not going to be providing any technical information on the invention itself. And so it's not going to be a huge problem. But of course, if I publish the chemical formula of my compound, then it's going to be a problem. And then there's the topic of this defensive publication, but I'm going to go back to that later on. This is a couple of examples of novelty and disclosures. So if we lose novelty whenever an invention becomes publicly available, and I would add, we don't have a date for a patent application yet, because if it's become publicly available after the date of the patent application, is not really a problem. If it becomes publicly available before that that date, then it's going to be a problem for novelty. And please, I'm talking about publication now, but this slide is to make sure that you understand that it's not just publication, but it's actually a lot of potential harmful activities, like, as you can see here, abstracts for conference, posters shown at public event, thesis, oral presentation in some cases, if you're unlucky enough that they are recorded, for example, and the examiner can see them. So it's a lot of different things beside publication that could create problems in terms of novelty. Again, provided that they happen before the patent application date. And now we get to the topic of defensive publication, because we spent time up until now saying that we need to pay attention about the fact that we need to patent before publishing, that we need to talk to the other partners, and so on and so forth. However, there are institutions, there are even huge companies, as we will see later, like IBM, that use this technique of defensive publication. And defensive publication is under like patent attorney point of view, a complete suicide, because it's publishing everything, all information, everything that that we have on something, making it, of course, unpatentable. But the point is that this is not patentable anymore for us, but not for anybody else, which means that this information is completely free of use for everyone, is completely usable from the community, and nobody can have this monopoly advantage of a patent about that anymore. And why would somebody do this? Well, first of all, because it is definitely cheaper than having a patent. Patents are expensive. A patent can cost up to 12, 13,000 euros, because you have the examination fees, you might have different territories, you have the patent attorney fees, and so on and so forth. A publication instead simply needs to be published online and retrievable by an examiner in order to stop all potential protection activities worldwide, which means that if I make my publication in Italy today, even in Italian, and somebody wants to patent the same technology in Japan tomorrow, they will not be able to do this, because the Japanese examiner is going to check, make a novelty check, and they're going to see that my publication in Italy actually already discloses the invention. So very bad luck for my Japanese counterpart inventor, but still very effective if, for example, I want to leave the whole community free to operate on this technology, and or I don't have, let's say, the economical possibilities to start a patent protection campaign. worldwide. So this is what we mean by defensive publication. And in order to make it effective, we need to ensure that it is public accessible, that it is indexed and searchable, and detailed enough, of course, to block the future patents. Publicly accessible and indexed and searchable is what I was saying before with the Japanese examiner, for example. My publication is going to be there online, and so they can find it. Detailed enough is what I was saying instead with the poster that I told you before. If my poster says, I have a prosthetic cancer cure, but nothing else, then it's not going to be a defensive publication. If my poster says, I have the prosthetic cancer cure, this is the chemical compound of the cure, well then, this is going to be detailed enough to block future patents. So what is detailed enough to block my patents, because there will not be novel anymore, then is going to be detailed enough to block also everybody else's patent. That's very important to remember. And there are many platforms that ensure that those 3 points are met. I have listed them down in here. Now, maybe there's a couple of questions I see, but I'll get back to that. Very interesting questions, by the way. I checked them out quickly now. So the access open, we have another point in Horizon Europe that we need to take into consideration, which is open access. And we know that we have to allow open access to publications and open access to the data that is generated by the project results. The access to publication and the data needs to be findable, accessible, interoperable, and reusable, which means that we need either to use open access journals, or even in some cases, if the journal is not open access, and we, however, are able to manage or ensure that the license that is going to be used is open access, then it would be fine anyway. But the point is that everything needs to be open in terms of publications activities, of sharing the data and the information. But please pay attention about the fact that open does not necessarily mean free of use. And this is a key point, in the sense that I told you, let's say my example of the my example of the compound that cured prostatic cancer before. Let's say that I have published the formula on open access journal. Now, everyone can see the formula, and actually everyone can take it in a way. So in this particular case, so the content, let's say, is in this particular case able for being used. However, the publication in itself is not free of use, because not everyone can simply take that word, is free to modify it and make it as if it was his, can be used the work, let's say the actual work, commercially. And very importantly, if I simply read the publication in itself, I might not know whether actually there is also a patent on that compound. So the paper will probably say it. However, there could be other intellectual property rights hidden behind that. And that's why I come like to another very important point, which is the fact that in 99% of the cases, intellectual property rights do not operate alone. And this is an example, for example, of the compound I was saying before, of patents operating together with publications and copyright protection. In fact, in my complete case, I was very diligent, and we could be, let's say, very efficient in our work. And so not only we have published our publication, let's say, on an open access journal, but also we had filed for patent protection before, which means that the protection is complete in the sense that nobody can take the uh, um, nobody can take the uh, paper that I used and modify it or translate it or adapt it to other uses without my consent. But at the same time, nobody is able also to just read the compound, see it, and use it for their commercial activities. Because again, here we were able to uh, cover those two layers of protection that I was saying before. So very importantly, copyright does not protect the content of your publication. It protects only the way in which it is expressed. And in our case of the prostatic cancer, I did to you the example. If there was a chemical compound behind it, it should have been protected also by the patent. And the same principle works with open data and also with the open access principle applied to that. I hope this is clear, and many intellectual property rights actually are applied together, as I was giving the example to you of the patent and the copyright, but many others like the database rights or in some cases trademarks. I have seen projects filing trademarks with their logo and their name because they wanted, let's say, simply to ensure in the future that the quality of the publications and also of the findings of the project, even after the project is over, is then covered. Um, Yeah. Okay. There are questions on the copyright, as I was expecting, on copyright and open data. So I will quickly finish the slides and then come to your questions regarding that, because they are very interesting questions. I'm very eager to cover them. But I will do it later on in the question and answer part. So thank you, however, for your interest and for your questions. I talked a lot about patents. I wanted with this slide to make a short parenthesis on the other intellectual property rights that could be applicable either to the publications like copyright or to the um, um, data that is generated by the project. For example, the database sui generis right. In fact, Camille was asking, I don't quite understand why open data is not considered public domain. Could you please specify the difference and maybe provide some practical examples? Well, in some cases, we might have database protection for data that is generated by the project itself. Database protection, basically in the European Union, safeguards those conglomerates of data that have been put together using a substantial economical effort. And so the authors, through the database rights, may restrict the extraction and reuse of the substantial part of the database, and it lasts a little longer than the copyright itself. And so this means basically, sorry, that we use we make the data available through um, 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 through the open access principle. However, there could be still some form of protection, like the database sui generis rights, that is applicable, that is applied to the database rights. And there is the recognition of the author and the owner and the creator of the database itself and the curator of the data. The same happens with the copyright protection and the publications. Those copyrighted publications are not public domain, just like the data is not public domain. There is another layer in between. In fact, the fact that we have an author that has generated, let's say, the publication, basically means that the copyright protection is still there. Only it is limited by the kind of license that is applied to that. In fact, copyright divides itself into two different rights: the right to be the authorship right, so the right of the author to be recognized as copyright holder, and the economical rights that are connected to that, which are the right to distribute it, the work to the public, the right to translate it, the right to modify it, and so on and so forth. With the vast majority of open access license, basically, the author waives some or all of these economical rights. Nonetheless, copyright protection is there. The copyright right is still there. So we are not in a case of open domain in a way. And the same happens with the database sui generis right and the database and the data within those data. The right is there. The right has been generated because the right generates automatically. Only the licenses that are applied to ensure the access to those rights are that they are very permissive. And so we are not in the public domain field, as you are saying, Camille. However, their access is much wider than it would be in a normal case, or say a private case of copyright or database sui generis right. I hope this these answers to the questions, but I will come back also to your questions later on. And examples of those licenses that allow the access to the data or the copyright are the Creative Commons licenses. I just made a couple of examples in here. That by providing attribution, so that's why also we're not in the public domain, because there's a need to provide attribution to in order to respect also this authorship right. Then we can use the data and the copyright, the data that, the data protected and the publications that are protected by copyright. So with these couple of slides, and also by looking at your question, my point here is that please don't think that because there is open access, because data is open, because data in a way is provided to be free of access, don't think that there is no intellectual property rights applied to that, that there are no rules that are applicable regarding the copyright discipline and the database right discipline. They're there, and we need to know them, how they work specifically and precisely, because it's not that, like in the question, open access equals public domain. This is a little bit different too. And it's important to be understood, especially in this webinar that is talking about patent protection, so protection activities and publication activities. Also here, I told you that's to stress the fact that intellectual property rights are in the largest majority of the cases interoperable, which means that they operate together because they cover different things. And so when we are reading a publication and we're reading its content, it could be that in there is going to be parts, or say the compound that I was making you as an example for the prostatic cancer before, that are protected by other intellectual property rights, in many cases patents as well. Um, I will skip this slide because actually I have told you already that the technical disclosure for a patent is there, so it's a dissemination method. I actually already told you this slide as well. Um, the protection of a patent is deeper than that of a copyright. And the answer to this first question, if my publication is protected by copyright, why would I want to file for a patent? Exactly for my example that we're bringing for the whole webinar together with us of the prosthetic cancer, because the copyright protects the way an invention has been disclosed. Sorry, my apologies. The copyright protects the way in which ideas are originally expressed, so protects the expression, whilst the content, so the actual compound, for example, cannot be protected by copyright, and so needs to be protected by other means. In our particular case, patent protection. And this allows us to control 100% what we have created. Instead, copyright protection by itself, in this case of prostatic cancer, wouldn't be enough. And I also see, I think I'm kind of foreseeing um, your questions, because one question was about AI, and so I have an example of this in my last upcoming slides. And this is an example of a AI-powered diagnostic app for early detection of Parkinson's disease. And we have a Horizon Europe project that is developing an algorithm that can detect Parkinson's symptoms from voice samples. So for me, this is completely science fiction, but still an interesting example. And so another part of the project will be other word packages with a mobile app to record the voice and generate the risk scores, and also a scientific article that is describing the algorithm and the results. So what happens is that the project publishes the scientific article that is going to be open access, and they use Creative Commons attribution, so anyone can read it, can share it, and can write it, and can cite it. Again, this is open access because of the license that we are using. It doesn't mean that it's completely public domain, because there is copyright. Only we are very permissive on the way that they can use this this publication. The algorithm structure and logic are described in this publication. And the article in itself is protected by copyright. However, what happens if somebody reads the article, takes the algorithm, builds another code upon it, builds an app, and commercializes it? Can they do that? Or eventually, can they also potentially patent this themselves? That's a very interesting question as well. And the answer is yes, they can use it because even if this algorithm could potentially be further protected by copyright, this is not a very strong form of protection, because if somebody takes it, remakes it so that it is original, the way that they have rewrote the algorithm, they have no stops. And they can be using that without any form of restriction. They could patent that. Mm, I don't know. Maybe yes, maybe not. It depends on how this algorithm differs from the one that has already been published. Because if it has been published, then and they basically slightly changing that, then the answer is no, it cannot be protected. If the changes are much deeper, maybe it could potentially also be protected by patent protection. But I would say 80% it's not going to be protectable by patent because it had already been published as a very similar algorithm in the paper. 20% potentially, if they make changes, they could eventually protect those improvements and changes through a patent protection. So again, here we have published, that's okay, but we didn't think about the patent. And so the point is that everyone then can see what's written inside the paper and take it, because the copyright does not protect the content, but only protects the way that content is expressed, which means that nobody can take, let's say, the expression and reuse it without our permission, and we are actually giving permission through the license that we are using. Um, um, but the thorough patent protection method that is applied is not applicable in here anymore. So what should have happened, and actually happened, that was just the crazy twist that I put inside the next slide. Actually, they had filed a patent for the algorithm and the scoring system before. And even if it was not written inside the publication, actually there was a patent for the algorithm and scoring system. Basically, the most important claims are a method for detecting motor impairment using vocal feature analysis, and a new system comprising an audio input module, feature extractor, and classifier. 18 months later, this patent has been published. So a little later than the paper, but still the patent application was filed before the day publication of the paper. And so the examiner, as I was telling you, is not able to check, let's say, cannot take into consideration what happened before, after the application date of the patent. So what happens now? We have a patent, so everyone again can read and learn and understand, and through the license also make use of the information of the publication. But in addition to that, there is a patent protection layer that specifically protects our method for detecting motor impairment and the system comprising an audio input module. So even if that is precisely described in the publication, even if through our publication we empower the reader to potentially be able to recreate the very same system, he will be able to do that because he can learn from it. But in the moment in which a competitor will want to enter the market with that specific method or system, is going to be having to talk to us because we are the owner of the patent that creates the monopoly, the legal monopoly that blocks him. And So what happens is that we fulfilled the open access obligation. The science is visible and citable like this and available for everyone. But at the same time, applying all the necessary intellectual property rights, we have retained the commercial control on the patent. And what can we do? We can take advantage, exploit our patent, because we can go to the med tech company and try to license that out for them. I hope this example is clear enough. I was trying to make some twist and everything. I understand that maybe, yes, maybe it's better to have all the information in one slide, but I hope that it can be of use. I also have an example of defensive publication, and I was also reading a couple of articles of how, and I found interesting basically how IBM uses this method, because we would expect that big conglomerates or companies, especially American ones, are, let's say, the patent trolls per definition. But actually, very often that's not the case. And these huge organizations are also, in a way, the cleverest in terms of spending reviews for their protection activities. And defensive publication in the case of IBM is a very useful way to save money on patent protection, save money on patent attorneys, save money on patent fees. And so what they do, they basically create prior art on the invention that they don't see strategically or and immensely important for them. when they think there might be a lower value. And so they create the prior art and block everyone else from protecting, especially patent trolls, because they create a novelty breaker. And additionally, they also somehow enhance their reputation because they keep innovation open and reusable by others. And there's no prosecution or maintenance fee. Think about maintenance fees for those giants. We're talking about millions of dollars per month. And so this is their example that I found. It was a simple optimization method for managing data center cooling for servers. But they didn't see it like incredibly direct product potential. But they said, okay, we don't see it, but what if somebody comes up with the same idea and they see it? So let's publish everything so that if somebody comes up, then they're not going to be able to patent that. And eventually we can take advantage of what they have understood, but we had missed in the past, and use it to our own advantage, because anyway, we have the know-how. This is a very quick example of defensive publication with which I wanted to finish my presentation today, also giving you a couple of useful tools. I'm going to jump right away to your questions because I see we already have a few of them, and I'm really, really eager to answer them. Again, for those of you who have connected a little later, I wanted to tell you that you're going to be receiving the slides and the recording of today's webinar as soon as possible, and ideally this afternoon or even tomorrow morning. We just need the time to process them, and yes, and they're going to be sent to you as soon as possible. Now, let's start with a couple of questions for you. First of all, I'm really, really happy that there's interest and already many questions coming up. And the first question, I don't understand how publishing grants any protection of the findings. It only renders copyright on the text of the publication, but not of the invention. Furthermore, publication terminates the possibility of registration as a patent. Yes, I think this question was from the beginning. I think I said it. The fact that theoretically the protection on the publication by copyright is there. So theoretically, even this is a way to fulfill, in a way, a form of protection on some of the results generated. So that if you are publishing a paper, there is anyway a form of protection, which is the copyright. I think that throughout the presentation later on, I brought out exactly what you're pointing out in this question. The content of the publication is not protected per se. And we have had the example of the prosthetic cancer that I brought with me throughout the presentation, or also of the app. It says exactly what Maciej, you're pointing out in here. It does not protect the content of the invention. So the formula is not protected, and the method and the systems are not protected by the publication. We need to have the cooperation between the different intellectual property rights. So you're pointing out this in here is definitely like the core of the whole presentation that I wanted to reach, from these initial points of the protection up until this cooperation within intellectual property right at the end of the presentation. I hope that it's more clear now, and that I answered already to this question. Just let me know again in the questions. Publication can be opposed to novelty and patentability. What about inventivity? What stand against invention? Previous state of the art? No, actually, in patent law, we have a definition of invention. This is also covered in our webinar, Introduction to Intellectual Property Rights. In the European Union, for example, the European Patent Convention gives us a negative definition of what an invention is. And an invention is that defined negatively in the sense that the European Patent Office, the European Patent Convention tells us what cannot be considered an invention. And so the legislator tells us a discovery cannot be considered an invention. A mathematical method cannot be considered an invention. A work of art cannot be considered an invention. A method to be applied to the human body cannot be considered an invention, and so on. So there are around 5 different exclusion into the definition of invention, and what falls into those categories cannot be considered an invention and therefore is not patentable. So it's not about the state of the art, but it's about Article 52 of the European Patent Convention that negatively describes what you cannot consider to be an invention, and therefore by reflex mirroring, what is not in there is automatically to be considered an invention. But great question. Only I answer in detail to this in another webinar, which is Introduction to IP, because otherwise we wouldn't have had time in here to cover all the other topics. May I provide some guidelines for assigning patent ownership when the research team consists of several people? Do you recommend limiting the number of patent co-authors, say 1 or 2, to facilitate the effective commercialization? And how to avoid potential team conflicts? I'm also going to show myself. Apologies for that. So you can also see me. Well, regarding this, it's important for you to remember that authorship in the patent is not the only relevant thing, but also it's very important that you remember that in patents, what is also important is the assignee. And maybe I still have it somewhere in here. I can show you eventually the assignee. You see applicant or assignee and inventors. There can be more than one inventor. There can be many of them. And also there can be many applicants in a way. Normally we have the physical person here as an inventor, and we have the juridical person for which this inventor is working up in here, which is the company normally. What is very like among the two, I would say statistically, the most important is the applicant. Sorry, I turned off my camera because the internet's not working well. Apologies again. But theoretically, yes, you can have as many as you want. You can have a multitude of them in here. Nonetheless, as you say, the limiting their number could be more effective in the sense that it will allow you to operate more freely without that much discussion. The point is that, and you can do that, no problem with this, only you need to find an agreement with the parties that are then left out from the patent protection activities. I saw in projects, I actually saw some parties that didn't want to be involved because having a patent, having a strategy for exploitation involves efforts in terms of time and in terms of money. And so they didn't really believe in the project or in the output after the project would be over. And so they simply said not to be taken into consideration in the procedures for protection. And so they didn't have taken into consideration then because of their wish. But if somebody is co-author, if somebody is joint owner of the results, then it's in a way his or her right to be taken into consideration as a co-author. And of course, I would recommend limiting the numbers in terms of efficiency to taking the necessary decision to exploit the results. but limiting the number not in an arbitrary way, but under an agreement that satisfies all the parties, definitely. And the team conflicts in there can be avoided through discussion. What can I say? Or through mediation by the coordinator, for example, or in some cases simply by agreement that says, okay, I'm going to be the the patent applicant, and I will be the one um, 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 like throwing the dice on the most important decision regarding the exploitation. At the same time, however, I grant you a royalty on every sell that I will be doing. So this way, basically, you don't have to do anything, and you're happy, and or the counterparty is happy, and I am as efficient as possible with the patent. It's a bold choice in the sense that you need to be really sure that the data working, but it could be then a way to avoid potential team conflicts. And then the next question, in order to evaluate the risks of early disclosures, could you please give an idea about the timeline from filing a patent and a publication on the EPO website of the pre-patent before the patent is really granted? I think I answered to this question as well when I did the example. The patent application is published after 18 after 18 months, and also that patent application that is published will be then a novelty blocker for future patents that are going to be filed because it's naturally it describes the technical content of the invention. I didn't quite understand why I opened the. I think this question I answered throughout the presentation. I hope the answer is clear. Camille, in case it's not, just write once again. And this was the one I saw about AI. Do you expect artificial intelligence to be used for prior state of art search, international patent search, or other activities linked to patenting? I was in a seminar a couple of days ago, very interesting. Actually, it was organized for the European IP Helpdesk ambassadors, where the speaker was talking about patent searches in AI with AI tools. And I wrote down the name. ChatGPT has also a dedicated AI tool for searching for novelty search, as far as I've understood in the meeting, which is Scholar AI. And my question here, that I don't know the answer yet, and I haven't received an answer yet, to be honest, was, but if I then, in order to make a public search, a prior state of the art search, I need to explain in detail my invention. And maybe if it was my prostatic cancer before, I will need also to explain to the AI the formula of my pill in order to cure prostatic cancer, to be honest. Not to be honest, just to the prostatic cancer. And so if I upload it in this Scholar AI, will it mean that also ChatGPT is going to learn it? And will it mean that if my colleague tomorrow is going to type for potential cures of the prostatic cancer, ChatGPT is going to tell her my formula and my cure? That is a huge problem because novelty then it is gone. So that is the reason why I don't use ever artificial intelligence, not at the moment because I haven't learned it yet, but I don't use even if it's existing, like this Scholar AI, I do not use it for the prior art searches because I'm afraid that the information that I share with the artificial intelligence then is going to be made available to somebody else and could be a novelty breaker for myself. I need to understand this hurdle before I can say yes, you should proficiently use it or not. How regarding publication, how can you have a Creative Commons license? How can it be valid? You need when the publication is downloaded, you need to specify that this kind of license is going to be applicable to the paper, and that basically the downloader accepts the conditions for the use of the paper. And it happens very often, like when we click and there was for those of you who watch South Park, there was a very interesting episode with the Apple terms and condition that we always accept and we always do. It's something, let's say, similar to that. When you download, you accept these terms and condition, and the license is basically in there. It started with Microsoft a few years ago when we would buy Microsoft 98, for example, and we would unbox it. This unboxing action was the way of acceptance that we had for the license. Just to give you an example. Now it doesn't exist anymore. It's just clicking. We are evolving, but the actions more or less are always that. No, exactly. So Lucia is asking, so there is no need to wait until 18 months until the patent is published to publish the result in a journal access. No, you need to have the application date. So what happens when you file for a patent? When you file a patent, basically, you present all the necessary information and you will receive a filing date. In the moment in which you receive that filing date, basically you can publish, because the publication is going to be after that. It doesn't matter if your publication is happening before the patent application is published after 18 months. The important thing is that your application date of the patent comes before the date in which the publication is then published. Going on, Lucia and Valentina, the Belgian iDepot has a value. I think I put iDepot here in the I didn't put it in here, but definitely, yes, it has a value. Why does it have a value? Didn't cover that 100%. Or say I was quick about this. Because copyright is starts to exist in the moment in which the work of art is completed, and work of art is over. However, if there is if we're fighting about the authorship, for example, of the work, we will need to prove that actually on that particular date we had finished the work of art. And so if we use one in like iDepot or I think Envelope Solo, also there is in France, or a simple registration method officially in Spain for copyright, for example. I know in Spain because I did it and it exists in there. Then we have a precise certified date in which my work of art had been generated. And I can prove it for sure in front of a judge that the copyright has perfectioned itself on that particular date. But I don't need it for the right to be existing. I just need it potentially if there is, let's say, a controversy regarding that, I can prove it in front of a judge. And is it possible to patent a novel bioformulate coming from patented single micro bio strains? So I would refer you to our webinar IP in biotechnology here, because Silvia, you're getting a little bit too biologic for me, and not not really an expert in the field. But just to say something about it, if you, let's say that you search on eSpaceNet and in the research engine, and you find this novel bioformulate that very interesting for you, you learn from it, and you can actually come up with something that improves it and hasn't been and is not part of the state of the art yet, so it's novel. Are you able to protect that, to patent this? Yes, definitely you are. because it is novel, because it is inventive, and it doesn't matter that in order to be able to use that, you need to have the previous the previous bioformulate that was patented. Doesn't matter as long as you are in the protection phase. Then if you want to use it later on, you might need also a license from the initial patents. It works basically like that. I cannot help you really in the 100% in the content of this, because I don't know what a single microbial strains are, and I'm really ashamed of it, but everyone is ignorant in different field. If a publication is made in a journal that is not open access, but the license of the publication is open access, is it still eligible for reimbursement of fees per EC rules? I was bringing over this point as a question a few weeks ago, because it was unclear for me. So the answer I received is that because open access because open access journals have fixed because all the journals have licenses for the user that are fixed, and they also always use that, and you cannot decide the open access license to be applied for a journal that is not open access. This case, theoretically, it would be the answer would be yes, it's still eligible for reimbursement, but you cannot have it practically in reality. That was I was answered to. So theoretically, yes, practically not, because you cannot have a license that is open access for a publisher that does not work. I see. Thank you, Anna. I see the thumbs up. Thanks a lot for that. I don't know whether Copilot is better than ChatGPT for privacy concerns. I don't trust the both, especially for novelty issues. Because if your invention gets lost, let's say the protection, because of the shares of ChatGPT. Actually, I tried asking yesterday to ChatGPT, telling it whether if I would put on my formula for my prostatic cancer, a very example that I use, as you can see, very commonly, what would happen? And he or she, it said that would be evaluating my requests on the basis of the formula that I insert, but then all the documentation would be canceled and it wouldn't remember that anymore. I didn't insert it, I didn't trust it. And I also asked, and what if I would have a non-disclosure agreement with somebody else who is the owner of that formula? And it told me that I would be in breach of that non-disclosure agreement, not because ChatGPT would be giving that to somebody else or disseminating again, but because of the fact that I am sharing that to a third party, which is ChatGPT, and so I would be breaching the NDA. So interesting question, though. I don't know Copilot very much. I use a little bit ChatGPT, but not that much as probably I should, in the sense that it's a very powerful tool, definitely. Only for some things we need to be very careful, especially legal restraints regarding non-disclosure agreement and also novelty issue. I think patent lawyers who do novelty assessment search on similar products, but never the actual invention. This is why it takes so much time and it is so costly. That being said, one could use AI like this, searching on similar invention. Definitely yes. And you would end up, finally, I would dare to say, you would end up searching into SpaceNet anyway, or those large research engine. Only probably you would be you would be more efficient in the search by using the artificial intelligence like Copilot and ChatGPT. I don't know. I have never done it through ChatGPT. If I search for something, I normally do it, and that's why I'm saying that I don't use it as I should probably, and I'm still a boomer or a millennial in under this point of view. I'd like to improve, but still I'm scared by a certain couple of points that are not clear yet to me 100%. I see the potential, Jonathan, definitely, and I totally agree with you that it's a very good way of searching for similar invention, and then you yourself read the abstract and the patent and do the understanding part to see whether the artificial intelligence actually got it right. So it's still time consuming, but it can point you towards the right answers. I apologize if I have missed some of your question. I don't think so. Just raise your hand if I've missed the question of somebody, because I was trying to read through the question, type them, and answer them all at once. And because I'm not that multitasking, but I don't think I have missed them. I am sorry that I took 15 minutes more, but I found your question extremely interesting, and I thank you very much also for answering them. Some of you have already left, but I thank a lot to those who have chosen to stay. I think the content for me was very interesting, and I put like all my effort in the preparation of this webinar. But of course, it can be, and I saw it also doing that, it can be improved. I thank you for those of you who are already giving me um, some hints on how to improve it. Don't be afraid of being brutally honest in the feedback when you will receive it, because it's all at my advantage, everything that you're going to be saying. So thanks a lot. And a special thanks to Michelle that has been listening up until now, I think.
Thank you, Michele. Very interesting.
Thanks a lot. And so see you, everybody, if you want to be with us in October and November. As you saw, the HRP and the European IP Helpdesk are going to come together again. We're going to be focusing on technology transfer and the new unitary patent system, which is still a big question mark for the vast majority of us. But I had the chance to work together with colleagues of the EPO, so we will unveil some characteristic of that. I wish you all a very lovely day, and see you then after the summer. Thanks a lot.